Recently, you may have heard one Kathy Blazer of Minnesota Citizens Concerned for Life go and testify against SF 473, which would essentially enshrine abortion access into law for any reason up to birth, as far as I understand. Now, this is a resurrection of a bill that was formally introduced a few years ago. But it's interesting to note that she starts talking about equal rights. But let's go take a look at what MCCL said just a couple years ago.
I've been in the media long enough to know a spin cycle when I see one. Democrats are running ads saying Republicans will ban abortions. Really? I know sometimes women have to make difficult decisions, but I also know Minnesotans want reasonable abortion laws. The truth is, the state Supreme Court has already ruled.
Any abortion ban would immediately be declared unconstitutional, period.
So when the Dems say there's going to be a ban,
they're lying to you.
Well, isn't that interesting? On one hand, you've got Michelle Tafoya, whatever her name is, over there talking about how, well, abortion can't be banned because somehow abortions are right. And on the other hand, you got Kathy Braindead Brainerd talking about unequal rights.
Abortion up to birth in innocuous language and attempts to dupe Minnesota citizens who overwhelmingly oppose unlimited abortion into unknowingly voting for just that.
And before I forget, the bottom of the little video Michelle put out, you see who it's paid for. Minnesota Citizens Concerned for Life Victory Fund. And then who posted it? Minnesota Concerned Citizens for Life. And so, since both of these women want to talk about the Constitution and laws and equal rights, well, let's talk about equal rights, equal protection under the law. What does Minnesota murder statute say? Well, they're primarily covered under Minnesota Statute 609, right? However, first degree falls under 609.185. And here's the key examples. Causing death with premeditation and intent to kill the person or another. Causing death during commission or attempt of first or second degree criminal sexual conduct with force or violence. Causing death during commission, attempt of burglary, aggravated robbery, kidnapping, or certain other felonies. Killing certain protected victims, peace officers, firefighters, judges, or children during child abuse. So killing a child during child abuse is considered first-degree murder, but ending their life in the womb, well, that's protected, right? And we call that equal rights, right, Minnesota Concerned Citizens for Life? So this is first-degree homicide. And I don't know about you, but it seems to me that someone premeditates the destruction of another human being's life when they secure transportation or drive themselves to a facility where they know they put children to death, walk themselves into the door after scheduling an appointment, sit down with the doctor, and proceed to have their child put to death. How is that any different than the premeditated murder of anyone else? And so you want to talk about equal rights, Kathy. You deny equal rights by, number one, working for the organization that you work for. Number two, by authoring, or not necessarily you, but the organization authoring the legislation that it does, which we'll get into in a moment. And we will see over the course of the entire history of Minnesota Citizens Concerned for Life, they have not once advocated for the equal rights of the human being in the womb. And so I propose to you that they are actually fraudulent in their fundraising because they don't do what they say that they are doing. And so, what are some of these laws, you may ask? 1973, Human Conceptus Law prohibits experimentation on living human conceptus, passed months after Roe v. Wade. 1974, Abortion Regulatory Law, extensive regulations post-Roe. Most provisions were later struck down as unconstitutional, but the physician-only requirement for performing abortions remains in effect. So long as a physician performs it, you're good to go. 1978, taxpayer-funded abortion ban. Banned state funding of abortions except in rare cases. Later ruled unconstitutional in 1995, Doe v. Gomez. 1981, parental notification law. Requires notification of both parents at least 48 hours before a minor's abortion with judicial bypass. So long as a judge signs off on it, don't need permission from the parents. You don't need to notify the parents, rather. No notification required. Upheld by the U.S. Supreme Court in 1990s, Hodgson v. Minnesota. 1981 and 1986 and 1991, abortion/insurance laws. Allowed HMOs to exclude elective abortions from coverage, 1981. Required maternity coverage and policies, 1986. Amended Minnesota Care Bill to prohibit abortion coverage, 1991. Later reinforced in 2013 to bar mandating elective abortion coverage in Minnesota. Sure. 1982. Baby doe protections. Protects disabled infants from denial of medically indicated treatment. Fetal homicide law allows penalties for killing or injuring an unborn child except in legal abortion. Passed after a court case highlighted the prior gap. 1987, fetal disposal law requires dignified disposal, burial, or cremation of aborted fetal remains, upheld in federal court. So, so long as you bury them or treat them with dignity after you've murdered them, we're good to go, right? Good to go. 1989, advanced directives, protections, added safeguards to living will legislation requiring continued care after transfer if a facility refuses treatment. 1991, Conscience Clause prevents discrimination in family planning grant funding against agencies that do not refer for or perform abortions. Assisted suicide prohibition clarified and strengthened the ban weakened by 2014 court ruling. 1998, abortion data reporting requires detailed annual reports on abortions. Reasons, methods, gestational age. 2000, safe place for newborns allows anonymous surrender of newborns at designated safe places to prevent abandonment/infanticide. 2003, women's right to know/informed consent results providers to inform women of gestational age, risks, development, and alternatives. 2005, Positive Alternatives Act provides annual grants, $2.5 million, to life-affirming pregnancy support organizations. 2005, Unborn Child Pain Prevention Act requires offering pain-reducing medication for the fetus after 20 weeks. Really? 2009, prohibition on taxpayer funding of human cloning barred University of Minnesota against the use of state funds for human cloning research. 2015, Born Alive Infant Protection, updated to explicitly protect infants born alive during abortion procedures. So as we can see, over the course of their entire history, not once have they ever advocated for the equal protection under the law of the child in the womb. And yet, they're going on TV, they're going before legislators and committees and testifying, saying, hey, we can't do this because XYZ unequal rights. When just a couple years prior, they released a video during the 2022 cycle, right? During the 2022 cycle, they released a video saying that abortion can't be banned. Well, let's get into that. Because what is the supreme law of the land? Is it a court decision? Is it a state law? Is it a state amending its constitution? Is it an executive order? Is it the Supreme Court? No, it's the federal Constitution is the supreme law of the land. And in it, the 5th and the 14th Amendments both forbid the taking of human life without due process. And the 14th strictly forbids the states from denying equal protection under the law of all the people that live within the borders of that state, under that state's sovereignty. And so you want to talk about equal protection? You want to talk about unequal rights? You deny them to the child in the womb, and then you stand on the backs of them as you fundraise for decades, pretending to fight abortion. Well, there's a new way, abolition. And all abolition says is the laws that protect you and me from murder also protects them. So to the legislators and to the people of Minnesota, abandoned by this organization, leave them. Join us. Join the cause. Go to equalpromm.org and go look at the evidence for yourself. Go to abolitionistrising.com and go look at the evidence for yourself. Go read their bills and see how not once have they ever advocated for equal protection. And then go and look at the legislation that Kristen Hawkins has in on a federal level that acknowledges that the child in the womb is a person from conception, is a human being, and afforded constitutional protections. But then at the very bottom of it says, nothing in this bill is to be construed as to charge the mother with the death of her preborn child. So only the mother can deny her child those constitutional protections that the law itself grants. May God have mercy on us all.